Hi guys, and welcome to my channel. My name is Diana Romanovska and I'm certified family law specialist practicing family law in San Francisco. Please be advised that this is not a legal advice kind of video. This is more informational to get you easing into the topic of prenuptial agreement. Today I would like to talk about 5 tips to a valid prenuptial agreement. And let's jump right into it. Tip number 1. Plan ahead. Please try to plan ahead at least 2 or 3 months or more. A lot of clients who came to my office and wanted to get married in a couple of days unfortunately weren't able to get a prenuptial agreement. Even if I did it in an hour, even if I prepared the agreement in an hour, it would not be possible because according to family law California section 1615, a prenuptial agreement needs to have 7 days at least for the other party to look over, to find a lawyer. It's not working out that way. However, if that's what happens to you right now and you're watching this video and like, oh my god. Anyway, I don't mean to be dramatic, but there is a post-nuptial agreement that you can look into. Tip number 2. Plan the terms of your agreement. Some people come to me and they're like, what typically people do in prenuptial agreements? It's hard to say because I can tell you what the classical prenuptial agreement would be, but it's also up to you. What would you like to have in this agreement? What would you like? And this agreement is not truly a living instrument. It's more something that is enforceable upon divorce. So it's kind of hard to think when you're in romantic phase to think about what do I want upon divorce, and especially if it's going to happen never, hopefully, but let's say it's going to happen in 20 years. And also what I say to my clients, don't worry, you can always change this agreement and make it addendum, have a post-nuptial agreement if you don't like anymore what you had signed up for 20 years ago. However, if we're right now in the moment and you're thinking to get married and you would like to think about terms, think about this. Would you like to receive spousal support and alimony? Would you like to not pay spousal support? Would you like to pay more than statutory under California law or less than? Or would you like to say, if we're married for 5 years and getting divorced, no spousal support, let's say it's a sunset clause, and then if we're married more than 5 years, then spousal support is appropriate. Things like that are very important to think about ahead of the time. And then tip number 3, gather all of your information, gather all of your assets and debts. Some people have a couple bank accounts, they don't have much, but some people have hundreds of pages and hundreds of bank accounts and investment accounts, and they're changing every day. So create a spreadsheet or have your accountant create a spreadsheet of all of the checking, savings, investment accounts, houses, everything ideally on the spreadsheet where you can see. Some people say, well, I have checking account at Chase. Well, in 20 years, maybe you have 15 accounts at Chase Bank. So we need to know which account was supposed to be a separate property account. So therefore, include 4 last digits of that account. Tip number 4, don't wait for your spouse to read this agreement. According to California law section 1615, Family Code, it says that the other spouse has to have at least 7 days to review this agreement, to find a lawyer. And there is also a recent case of appeal that says no significant changes, California case of appeal I have to say, no significant changes are allowed to be made in order to have a valid prenuptial agreement for 7 days before signing it, assuming it's going to be signed before the marriage. It's called prenup, that's why. So imagine you have a prenuptial agreement, you're getting married in a month, present it to your spouse as soon as possible. And then the final tip, have your spouse have a lawyer as well. So there are some conversation about it, but the bottom line is, one thing is clear. If there is a spousal support waiver in this agreement, the party who is enforcing it later, if that party says you need to pay me spousal support and you say, well, we have a waiver, so the party who is enforcing it, who wants spousal support, if that party wasn't represented by a family law attorney, then the prenuptial agreement is not valid. And how do you know 20 years later whether or not the spouse was represented by a family law attorney? Well, you can see it if the other lawyer signed this agreement on its face. There will be a presumption that that spouse was represented. So ideally, I always suggest that both parties are represented by two separate attorneys. So some people come to my office and they say, why don't you do a prenuptial agreement for both of us? We're in agreement with everything. It makes sense. Yes, but here's the thing. There is so-called conflict of interest. The prenuptial agreement is in itself could be potentially conflicting. Some spouse has more, some spouse less. Eventually, there will be a conflict. I never do that. I always suggest that the other spouse hires another lawyer who is more independent, who didn't draft the agreement, who can review it and find some negotiations point, or if there are no negotiations, at least explain what the other spouse is signing. I hope that helped, and I will see you soon. Bye!